Okay, let's go ahead and get started. Good afternoon, everyone. Welcome to today's webinar. My name is Dina Johnson, and I am from JFK Partners, which is part of the section of Developmental Pediatrics at the University of Colorado Anschutz Medical Campus. Today's webinar is The Housing Crisis for Coloradans with Disabilities, Know Your Rights and Resources. It is a collaborative webinar by the Colorado Developmental Disabilities Council, Disability Law Colorado, and JFK Partners, which is Colorado's University Center of Excellence in Developmental Disabilities, or UCED for short. The Developmental Disabilities Assistance and Bill of Rights Act of 2000 outlines these three agencies as the Developmental Disabilities Network partners for every state and charges them with jointly identifying and addressing critical issues or barriers affecting individuals with developmental disabilities and their families. Each group conducts needs assessments to plan their work and set priorities. Housing comes up as one of the most critical and challenging issues. And that's what brings us here today. And so I wanted to share with you these links I'm going to put in the chat because Disability Law Colorado is actually conducting their annual survey right now for their needs assessment. So if you could help them out by providing them some information, that would be very helpful. So on this slide, you can see each of the three agencies, and they each have different charges. So the DD Council works to address identified needs by conducting advocacy, systems change, and capacity building efforts that promote self-determination, integration, and inclusion. And the state P&A, which is Disability Law Colorado, is dedicated to the ongoing fight for personal and civil rights of individuals with developmental disabilities. And then the UCED, which is JFK Partners, are affiliated with universities, allowing them to serve as liaisons between academia and the community. So with that, I would like to introduce you. Oh, before I introduce you, I would like to do a couple of housekeeping items. So if you could be sure to keep yourself muted so we avoid any background noise. And feel free to type in questions in the chat. We'll hold the questions until the end. But we will capture all the resources and links that are shared in the chat in a document that we will share after the event. So feel free to share. We are recording today's event, and that will be archived on the JFK Partners website along with the other two agencies' websites. We have actually already posted the handouts for today, and you should have received an email with those, but I'm going to put the link in the chat so you have access to those right away. And following the webinar, you will receive a link requesting an evaluation. And in there, we do ask a few extra questions to guide our work around this particular topic of housing. So we hope that you take a few minutes to complete that evaluation for us. So today's speakers include Kelly McCullough from Disability Law Colorado. And Kelly has been practicing law since 2010 when she graduated from Washington University in St. Louis with a law degree and her master's in social work. She spent 10 years as an attorney with the Colorado Public Defender's Office. And prior to law school, Kelly worked as a mental health social worker in Ohio. She joined Disability Law Colorado in 2020 as the Access Team Leader. and is excited to keep fighting for disability rights as the legal director. Kelly spends her free time woodworking and cooking. And Renee Payne joined Disability Law Colorado as the Community Integration Specialist in 2022. She grew up in Denver and studied Spanish, Portuguese, French, and human geography at the University of Colorado Boulder. After graduating, she lived and worked in Brazil through a Fulbright English teaching assistantship. She returned home to Colorado and specialized in public benefits, eligibility, and appeals. She then attended Northeastern University School of Law as a public interest law scholar. And while in law school, she interned at Massachusetts Protection and Advocacy Agency. She graduated with her JD in September of 2022, and she was thrilled to move home and start her career as an advocate at Disability Law Colorado. And then we have Jennifer Penhale. She is an active duty Air Force spouse of 20 years and mother to 3 teenagers with autism, her twin daughters having severe profound autism. She has been a longtime advocate for military special needs families and has been involved in various grassroots efforts and advocacy for the autism community as well. She holds a master's degree in public administration and is proud to serve on the Colorado Developmental Disabilities Council to represent individuals like her daughters who need a voice while promoting acceptance, integration, and inclusion on the local and state levels. And lastly, but not least, we have Jack Johnson, who is the public policy liaison for Disability Law Colorado. He spent the last 6 years working on elections and public policy in Colorado, including several years in the Colorado State House. He holds a bachelor's degree from the University of Colorado in molecular biology and will graduate, or may have just graduated, with his JD from the University of Denver. Jack joined Disability Law Colorado in 2021 as a legal extern, working with the Access team, and has since transitioned to working alongside the team leaders on legislative advocacy and policy issues. In his free time, he enjoys coaching Little League Baseball and traveling. So with that, I'll turn it over to Kelly to get us started.
Sorry, couple minutes or a couple seconds to do the video. Hi, I'm Kelly, and thank you for that introduction, Dina. I don't know if you can hear that I am a little sick. I actually have COVID. So excuse me if I'm coughing or blowing my nose during this presentation. To go over our agenda, talking about the purpose of webinar and introductions, and then rights in housing, and talking about rights in housing and community housing, regional centers, group homes, host homes, family host homes, and resources in housing and legislative updates related to housing. I want to start off with the purpose, talking a little bit more about the purpose of this webinar. We know that housing is a pivotal issue. We also know that we don't have all of the answers. We're focusing on advocacy work, trying to come up with solutions on legislative and litigation fronts and every front that we can imagine. But this is really focused on knowing what your rights are and knowing some of the resources that are out there. And I know based on the attendees who are coming, there's many of you who are also have a lot of knowledge in this area. So as we're going through, if you have other resources that you would recommend, I encourage you to put those in the chat. Going on to the rights in housing and community housing. And we're starting here because most of these laws, or all of these laws, also often apply to the other types of housing that we're going to be talking about as well. So we're starting here because it applies pretty much across the board. So the Fair Housing Act includes federal protections for people with disabilities against discrimination in housing, the Colorado Anti-Discrimination Act, which has state protections for people with disabilities against discrimination in housing. Section 504 of the Rehabilitation Act offers additional protections for people with disabilities in government-owned housing, and the Americans with Disabilities Act offers some protection to areas of housing that are open to the public. So Fair Housing Act exceptions. So there's most housing falls under the Fair Housing Act, but there are a few exceptions. Housing that is owned by religious organizations may be exempt. It is a more complicated test. It's not very straightforward in terms of whether it applies or not. And some people who might know some things that are coming out with the Supreme Court know that the religious exemptions are getting extended beyond what they used to be. So that is also kind of in a state of flux. Private clubs, a house that's a quad or fewer. So if there's 4 or less apartments and the owner lives there, that would include, so if an owner of a home opens it up so that somebody can rent a room, or 3 people could rent a room, that would also be an exception that doesn't fall under the Fair Housing Act. However, there was new legislation in the state that might make it fall under CADA, the Colorado Anti-Discrimination Act, even if it's a quad or fewer. So that doesn't mean that they are free to just discriminate willy-nilly. That CADA might apply. In single family homes, if no realtor, less than 3 homes are owned and there's fair advertising, and some senior housing are the exceptions. Rights in community housing for prospective renters. You cannot discriminate on the basis of disability in renting. Housing provider has to offer reasonable accommodations to applicants in the rental process. So one of the ways that this can come up with people who are looking for housing with intellectual disabilities is that sometimes we see discrimination on the basis of income. And there's actually a newer Colorado law that passed in 2020 that says that they cannot discriminate on the basis of income. And that includes if your income that's allowing you to get the housing is coming from HUD is a voucher, if you're getting SSI or SSDI, there's no ability to discriminate on the basis. They can still have income limits. So, they can still say, if you don't have your income at 3 times the level of this very expensive place, then that obviously will end up foreclosing anybody who's getting SSDI, typically from being able to rent there. But they cannot say that we don't accept this type of housing, or we don't accept vouchers anymore. Another newer Colorado law passed in 2019 says that you cannot consider rental or credit history beyond 7 years, and cannot consider any criminal history more than 5 years old. There are some exceptions to that. And I don't know, looks like the end of the statute got cut off. I can put that in the chat later. But so there's some exceptions. It's pretty limited exceptions. It's very, very serious crimes, and stalking and manufacturing of methamphetamine are pretty much the crimes, and sex offenses. So this can be beneficial for people with disabilities, both because we know that people with disabilities are disproportionately targeted under or disproportionately represented in criminal offenses, and also that based on some of the income issues that may come with having disabilities, it may be you may have somebody with disabilities may have a just like anybody else, but can also have a history of credit issues with rental history. So what constitutes discrimination? Refusing to show, rent, lease, or sell, denying availability, unequal terms, conditions, or privileges, different rents or security deposits, different rules for eviction or non-renewal, harassment, unequal maintenance, higher interest rate or predatory terms and conditions, discriminatory advertising, blockbusting, redlining, uh, denying reasonable accommodations or modifications, which is what we most often see, and retaliation. So, one of the things that we have seen come up with in the application process is using the source of income or a lack of steady income to say that they're going to deny housing when it definitely seems like it's covering for uh, disability discrimination. We also can see where they use service animals or emotional support animals as a reason to try to deny, which is also illegal. Um, and just not making accommodations in the running process is something that we often see, and is something that is illegal. Reasonable accommodations. So the definition is a change, exception, or adjustment to a rule, practice, policy, or procedure, or service that may be necessary for a person with a disability to have the equal opportunity to use and enjoy a dwelling, including the public use or common use spaces. So, and some examples of reasonable accommodations are creating an exception to a first come, first serve parking situation. They might have to make a reasonable accommodation to assign a close up parking spot to somebody with a mobility disability, allowing a tenant to pay rent by mail versus, requiring them to use an app or something that's not accessible. Allowing an assistance animal in a no pets building is another example. So it's not changing the structure, but changing a rule, policy, practice, or procedure. And landlords and property managers are required to make reasonable accommodations so long as it's practical and feasible. Um, is it an undue administrative or financial burden? So is it going to cost, way too much for this person to do the reasonable accommodation? Now, they do have to take into account the whole overarching finances of the landlord or renter, rental owner. So, some of these landlords or rental management companies own a substantial number of properties, and therefore, whether it's a financial burden would be highly questionable for most reasonable accommodations, because if they own that much, almost nothing is a financial burden. Is it a fundamental alteration of the program? So in the case of housing, it would be asking a landlord to do something that's different than what they would do for any resident that's outside the scope of what they would normally provide, like a service they would provide. So asking your landlord to deliver meals to you would be something that if a housing situation doesn't provide meals, doesn't deliver meals, doesn't do anything with food, that would be an example of a fundamental alteration. Is it a direct threat? So direct threat is a complicated issue, but an example of a direct threat would be somebody has an emotional support animal that is not is dangerous, is maybe a wild animal that there's always the articles out there that are the exception and not the rule, and I hate them when they come out, but an emotional support peacock or something that would attack your neighbors would potentially be a direct threat and therefore not a reasonable accommodation. Is it related to the disability? So it has to be something that is tied to the disability and not, just, kind of something that somebody would like to have happen. Housing providers cannot require people with disabilities to pay extra fees or deposits in order to have reasonable accommodation requests granted. So we see this a lot with service animals and emotional support animals, is charging an extra fee or a deposit. But there's also examples where landlords have tried to do that for someone who uses a wheelchair, trying to argue that it would damage the floors or carpets. Um, and they cannot do that. However, if there were damage that came from a service animal when that person left, they would have to pay it if the landlord would make anybody who has an animal in their apartment pay for the damages. But if it's like ordinary wear and tear, no. Reasonable modifications are a structural change made to existing premises, occupied or to be occupied by a person with a disability in order to afford such person full enjoyment of the premises. So reasonable modifications, examples would be widening doorways, installing grab bars, lowering a kitchen sink, and adding a ramp. With reasonable accommodations, or sorry, reasonable modifications, the tenant generally has to pay. So what the obligation is for most landlords and rental managers is to allow, to permit the modification, but that the tenant would have to pay to have it done. They would have to pay to have it done by somebody who is a professional, or to have it done in a professional manner. It can't be kind of just shoehorned and potentially cause some damage by like a DIY project or something like that. Um, and it is however, landlords that receive federal funds may be required to pay for the modifications pursuant to 504. So a housing authority owned apartment, so one that is owned by the housing authority, not just one that frequently accepts vouchers, but one that's owned by the housing authority, would have to pay for modifications, and the tenant would not have to pay. That is there's of course a gray area with other apartments that have received some substantial amount of federal funding, but aren't necessarily fully federally funded. There's definitely kind of a gray area where you can make the argument that some of the places that have taken a substantial amount of federal money would have to pay. Tenant also would have to pay to restore the modification back to the way it was if it could affect the use and enjoyment of the future tenant. This is for interior modifications only. Exterior modifications do not have to be restored. Um, an example of something that would not affect the enjoyment of a future tenant is if you put in um, support beams under the walls to help with to put in the support bars and grab bars. That would be something that could not affect the use or enjoyment of a future tenant. What can a housing provider ask when somebody asks for a reasonable accommodation? They can ask whether the requesting party has a disability as defined by federal and state fair housing laws.
Hello. She called you, not me.
So I think somebody's not muted. If you could mute. So excuse me. Thank you. So it could be, the proof of disability could be from a medical professional or from a disability determination, like something made a letter from SSA that determines that you have a disability. Whether the requesting party needs the accommodation, so they it has to say something about what the need is. It needs to be tied to the disability. So something that says this is a need that we have I have because I have severe anxiety, and therefore I need to have an emotional support animal. My cat helps me with my anxiety by, being there, prodding me to pet them when I'm in an anxious state. And so you can also have a person in the know help with proving that up. So rather than having a doctor say, I've seen or that person's cat helps them, the doctor could establish the disability, where a person in the know, someone who's seen you interact with the cat, could say, I know this person has anxiety. I know that their symptoms can be really bad. And when the cat prompts them to pet them, that calms them down and their anxiety decreases. And that can be a way to prove it up when a doctor is like, I don't really know to say that, the cat would help. I just can say that you have the disability. The landlord must reply promptly without undue delay. There's delay is something that the courts have found to be a constructive denial. So they haven't said yes or no, but it actually comes out that it's a denial, because if you just say if you just refuse to say yes or no, that's not allowing that person the accommodation. If the need for the accommodation is apparent, you cannot ask for documentation. So if somebody is saying, I need a reasonable accommodation for a service animal, and that person is clearly someone with a visual impairment who has a dog that they use as a guide dog, then you cannot ask for a landlord could not ask for documentation under those circumstances. Okay, and I'm going to hand it off to Renee. Oh, before I do that, I just want to say really quickly, one of the handouts that is provided on the link that Dina shared is our housing packet, and our housing packet has a little bit more in-depth information about these laws and rights and how to file complaints if these rights are violated. And it also has a sample letter, a template letter for requesting a reasonable accommodation from a landlord or property manager. Okay, now I'll hand it off to
Great, thank you, Kelly. So I'm going to be talking about these 3 specific settings and all the rights that apply that Kelly just mentioned that apply in the community also apply in these 3 settings. So I'll be discussing regional centers, group homes, and host homes. And these are 3 settings specifically for people with intellectual and developmental disabilities, which I'm going to abbreviate and is abbreviated throughout as IDD. And so these 3 settings are accessed through a Medicaid home and community-based services developmental disabilities waiver. And so this is essentially a Medicaid program, and the community-centered boards currently administer the home and community-based services DD waiver. And community-centered boards are social services organizations, and they're approved by the state of Colorado to determine people's eligibility for the waiver program. And this is how it is currently working. This is going to be changing in the next couple years. The state is currently trying to separate out the eligibility determination for the DD waiver and the case management services, because they decide that's a conflict of interest for the CCBs to be providing both eligibility determinations for the waiver and the case management services. So this process, the names of the different agencies and things like that will be changing slightly in the near future, but the home and community-based services waiver will stay the same. The eligibility will stay the same. It just might be a different agency that people will go to access this waiver. And I believe someone might be off mute. If everyone could confirm that they're on mute. Thank you. And I have a link here for the community-centered boards by county. Next slide, please. So in order to be eligible for a home and community-based services developmental disabilities waiver, there's several eligibility criteria. So the main one is that the person with IDD has to need supports and services 24 hours per day. So when they go to the community-centered board to apply for the DD waiver, the community-centered board is going to make a disability determination, and they're also going to do a supports intensity scale assessment. And that's that's basically what's going to determine if the person does need services and supports 24 hours per day. The other eligibility requirements is that the person with IDD must be 18 years old or older. They must have income less than $2,742 monthly. That amount changes each year, but it is always 3 times the amount of the monthly supplemental security income amount. So there is no requirement that you have to be on a certain Social Security program. You don't have to be on SSI, or you don't have to be on SSDI to get this waiver. It just has that numerical income amount. There's also a resource limit, and that will vary depending on if the person is single or if the person is married. And so basically, once you are eligible, found eligible by the CCB for the DD waiver, then the CCB is going to work with you, the person with IDD, to put together their individualized plan. And so this is with an interdisciplinary team of doctors, therapists, case managers, and they're going to create this individualized plan, which is going to determine the specific supports and services that the person will receive. And it's a requirement that this individualized plan must be reviewed at a minimum annually. Next slide. And then, so just going into a little bit more about what each of these settings look like. So it's organized based on the most restrictive setting to the least restrictive setting. So a regional center is a large facility for people with intellectual and developmental disabilities. And this is what's, they all look a little different, but this is what's going to most resemble more of an institutional setting. And there's 3, these are operated by the government, by the Colorado Department of Human Services. There's 3 regional centers in Grand Junction, Pueblo, and Wheat Ridge, which is more or less the Denver metro area. And total, there are 44 group homes that these regional centers operate. So someone might be placed in the regional center, more the facility institutional center, or they might be placed in the group home, depending on their individual supports and needs, and that will be determined by the individualized plan that the person creates with the regional center interdisciplinary team. Next slide. And so then group homes are sort of the medium level of restriction. So they're less restrictive than the regional centers, but a little more restrictive than host homes. And so it's a group living arrangement for between 4 and a maximum of 8 people with IDD. And there's rules around it being integrated into the community. So this is really meant to be sort of in a neighborhood setting. So there's rules about how close the host home can be to other hosts, how close the group home can be to other group homes, or how close the group home can be to day programming or other services and supports for people with IDD. And so that's what is meant to create sort of that neighborhood feel, so that the people who are living in the group home are not solely interacting with people with IDD, they're also interacting with people without disabilities, getting out into the community. So that's why there's those rules around integration and how close it can be to other group homes. And the group homes are operated by program approved service agencies, which are abbreviated as PASAs. And so PASAs contract with the CCBs, with the community centered boards, to provide the services and supports in the individualized plan. And so the PASAs, they look very different because they're contractors. And so it varies by region, and they can be very small providers, and a PASA could maybe operate 1 group home and 1 host home. And so then it might feel more like a family, a very small, close-knit organization, or there's PASAs that are quite large and feel more like a CCB, that are a large social services organization with multiple group homes, multiple host homes, tons of different providers. Maybe they're also running day programming services or lots of other transition services. So there's a large variety of PASAs, and it'll just sort of depend on what's available in your region and sort of what you are looking for. Next slide. And then finally, host homes are the least restrictive of these settings. And so this is a type of shared living arrangement in which the person with IDD and people without disabilities choose to live together. So this is ideally sort of a roommate situation, that the person without disabilities is the host and they open up their home to the person with IDD, and then they live there as roommates, as peers. Medicaid, through the Home and Community-Based Services Developmental Disabilities Waiver, they will pay the host, the person without the disability who's opening up their home. And there is a maximum of 3 people with IDD who can live in a single host home. So a host can only have 3 people with IDD living with them. And then they usually receive services, people usually receive their services in the community. So the host does not have to provide all the services that the person needs. And ideally, they are going outside. The person with IDD is going outside the home to receive those services. So they might go to day programming, receive therapy outside of the home, have a job outside of the home, and then they come back just like a roommate and go back to their host home. Next slide. So I will now go over sort of the rights that apply in all 3 of these settings. Host homes have some additional rights on top of this, but all these rights that are in regional centers, group homes, and host homes. And these are statutory rights that are found in Colorado law. So they're very strong and very clear. So the first one is that a person with IDD has the same legal rights as a person without IDD. So that's huge, that there's the exact same legal standing. The only difference would be if the person with IDD is under a guardianship is essentially when a court is taking away rights from someone and giving them to the guardian. So that would be the only exception to this right. People with IDD also have the freedom from discrimination based on their disability or their status as someone on Medicaid receiving a Home and Community-Based Services Developmental Disabilities Waiver. They also have freedom from corporal punishment, which is physical punishment, freedom from mistreatment, exploitation, neglect, abuse, and seclusion. And you'll notice that the only one that's missing from this list sort of thematically is freedom from restraint. And the law does allow for very limited circumstances of restraint. So it is not there is not complete freedom from restraint under the Colorado law. And so the very specific circumstance in which restraint is allowed is to protect the person with IDD from injury to themselves or others. So there's a very narrow exception to freedom from restraint. They also have freedom of religious belief, practice, and worship, as well as freedom from censorship of mail and packages. And so that would include in the host home that if their host should not be opening their mail, their packages, things like that, respecting them just like they would a roommate. Next slide. So then this is sort of, these rights are more related to their treatment and sort of the services and supports being received through the CCB. So by law, they have a right to an individualized plan. They also have a right to preventative medical care, preventative dental care, as well as any accompanying medical and dental treatment. And so this one I just wanted to highlight because it is quite expansive, that it really goes into detail, and it's an expansive right to medical care, dental care, and treatment. They also have freedom from unnecessary or excessive medication. And this right includes having prescriptions and medications reviewed at least annually to make sure that they're still the most appropriate medication, still being prescribed at the correct level. And so that's why that review has to occur annually. They have the right to a humane physical environment that includes support from qualified staff and a sufficient number of staff to meet their needs. They also have the right to confidentiality of their records, and it's the duty of the CCB, the Community Centered Board, to maintain this confidentiality. Next slide. They also have the right to communicate freely and privately with whom they choose. And this right also includes in-person visits, access to telephones. This is the same in a regional center, in a group home, and in a host home. And basically, this right is also very expansive in the law and is really focusing on an overall goal of, or what seems to be an overall goal of, a right to choose who the person with IDD is interacting with, that they have that right to choose who they're interacting with, who they're communicating with, when they want to do that communication. So regardless of the setting, they have that right to choose the best communication with who they want to communicate with. And then the next one is they have the right to work and get paid for that work. And so this is also employment protection is very strong in the law for people with IDD. And so there's lots of protection. So an example would be that, let's say someone with IDD is living in a host home, and that host cannot force the person to do house tasks that they would pay someone else to do without paying the person with IDD. So let's say you're living in a person with IDD is living in a host home. The host cannot force them to mow the lawn, trim the trees, do sort of like those manual labor tasks in the home that they would pay or might either do themselves or pay someone to do. So they could employ the person with IDD and pay them for that work. The only sort of exception to this is like daily housekeeping, just like a roommate situation, that if it's in line with the person's individualized plan, the person with IDD will be expected to do sort of the daily household keeping, maybe tidying their room, tidying the kitchen and the common areas. But there's strong labor protection and employment protection that a host or someone who's running a group home can't force the people living there to do employment work without getting paid, without getting compensated for that employment work that they're doing. And so then the next right is personal property, that in any of these settings, even if it's a more restrictive setting, they have the right to their clothing, their money, all their personal things. And the person with IDD, they may choose to have the service provider, so either the PASA, maybe the regional center, hold their money in a trust, but that is a choice that they can make. They're not required to have a trust. They also have the right to vote and receive voting assistance if necessary. And so the right to vote, if they do need assistance and would like assistance, then it is either the regional center or the PASA who's running the group home or running the host home. They would be the ones who would provide that assistance. And then they also have a right to form a committee to influence the service provider's policies. And so this would be a committee of peers of people with IDD who are maybe all living in the same regional center or group home and want to influence the provider's policies. And then they also have a right to notification of changes to the service provider's rules. And this notification must be accessible, and it must be in a language that the person speaks or understands. And then one final right that I forgot to put on the slides, this is not a statutory right, but comes from a Supreme Court case under the case of Olmstead versus LC. Every person with IDD, as well as every person with a disability, so this is a very broad right, has the right to live in the least restrictive setting that meets that person's needs. And so this right should ideally include transition services. So let's say someone is in a regional center, but now they want to step down and be in a group home, be more in a neighborhood, be more integrated into the community, and that will better meet their needs, then they have a right to move into that group home. And so this should ideally have this should be accompanied with a right to transition services. That's not always seen in practice, but that is another right that is not just limited to these three settings, but definitely comes into play since these settings sort of go from a more restrictive with the regional center to a less restrictive with the host homes. Next slide. In all three of these settings, there's protections around suspension of services. And I wanted to highlight that services can only be temporarily suspended. They should not be permanently suspended, but temporarily suspended if the person with IDD is a serious physical threat to themselves or others, and suspending those services would protect the person with IDD or others. These services cannot be suspended if suspension would put the person at risk of houselessness. And even while their services are suspended within one of these settings, the person with IDD maintains a right to case management services as well as other services that will support them in regaining the suspended service. Something that comes to mind could potentially be therapy in this context, that the setting cannot just suspend all services across the board, that those case management services should always be there. They still have a right to those services, and they should be receiving services that will help them remove this temporary suspension. Next slide. And so then there's also some sort of procedural rights, or sort of the administrative part of when people must be notified for all of these settings. And so the service providers, so the CCB or the PASA, must provide a 15-day notification when the person is not eligible for services. So when they make the disability determination or do the assessment and they determine that they're not eligible, they must be notified. The person with IDD must be notified within 15 days. They must receive the same notification if their services are terminated or temporarily suspended, like we talked about in the last slide, or if the services in their individualized plan are reduced or denied. The service providers must also have a grievance policy, and they must give that policy to the people with IDD when they are admitted to these settings and when there are changes to the policy. And we already learned that there's a right to notification to any changes in those policies, and that all of these policies must be accessible. And if someone asks to have them read to them, explained, anything like that, then the service provider has to do that. That accessibility is a requirement as well. Next slide. And so now these are just a few slides with some specific rights just for the host home context. And this is sort of reflective of the shared living arrangement where it's sort of a roommate type of situation. And so host home residents have the right to manage their own money and possessions, to have their own bedroom, unless they choose to share with a roommate, and that could be a person without disabilities or a person with IDD. They have a right to have their own key to the host home, to have a lock on their bedroom door and their bathroom door, right to access the kitchen and common areas of the house, living room, family room, TV, things like that. They have a right to access food at all times, and a choice of when, where, and what they want to eat. Next slide. Homes, there's a very narrow limitation on the rights that I just went over. And so once again, these rights may only be temporarily suspended. They cannot be permanently, but they must be temporarily suspended if the person with IDD were to harm themselves or others, and the right is suspended by a qualified professional in consultation with the resident's interdisciplinary team. So this second part basically means that the host of the host home cannot suspend the person's right, because it's very unlikely that the host of the host home, the person without disabilities who the person is living with, they're probably not a qualified professional. They're just a community member, someone who opened up their home and is being paid by Medicaid. And so that means this qualified professional is someone from the PASA, from the CCB. And so basically the host of the host home cannot suspend someone's rights. So they cannot take away what we just went over. So they cannot suddenly forbid the person from going into the kitchen. They have a right to access the kitchen, to access food at all times. So the host cannot do that. It has to be this qualified professional. And during this process, the resident, the person with IDD, has rights as well. They have to be notified that their rights are being suspended by the qualified professional. And the rights suspension must be reviewed by the Community Centered Board's Human Rights Committee. All community centered boards have a Human Rights Committee, and it's made up of these type of qualified professionals. And the person also has the right to provide information and their side of the story to the Human Rights Committee through this process. Next slide. And finally, we have these procedural rights, which are specific to host homes. And so the agency must provide a 15-day notification prior to any proposed changes with a resident's host home placement. And so the agency we're referring to here is the PASA. And so the PASA has to provide that 15-day notification. They also have to notify the residents of their right to appeal any proposed changes through the agency's, the PASA's grievance procedure. The PASA must notify the resident annually of their grievance procedure, and residents must have an opportunity to participate in the PASA's Consumer Satisfaction Survey, which must occur at least every 2 years. And now I'll turn it over to Jennifer to talk about the sort of host homes and the parents' perspective. Thank you.
Hi, thanks, Renee. Good afternoon. So I will speak a little bit on the family caregiver option for parents and family caregivers. But first, I'm just going to give a little bit on the our council stands. So the Colorado Developmental Disabilities Council takes the housing crisis we have here in Colorado very seriously, particularly in how it impacts our IDD community. And such a housing crisis leads to further isolation and segregation for those in the IDD community. So unfortunately, the fact that we're having a webinar calling attention to this ever-growing crisis means that there's still much to do in order to secure more affordable and stable housing for those with disabilities. So the Colorado Developmental Disabilities Council has been a staunch advocate for Coloradans with IDD securing integrated housing within the community. And it's the council's aim with partners to increase the understanding of competitive integrated employment and integrated housing among Coloradans of all backgrounds with intellectual and developmental disabilities and their families. And the council and its partners also have the goal of increasing the capacity of self-advocates and family members of all backgrounds to effectively advocate to live and work in inclusive integrated environments. So in addition, the DD Council also aims to advance changes to policy, practices, or systems that increase opportunities for Coloradans with intellectual and developmental disabilities to live and work in inclusive integrated communities. And finally, the council and its partners intend to increase representation of the interests of Coloradans with intellectual and developmental disabilities and their families in coalition advocacy and systems change efforts to increase affordability and accessibility of general housing stock statewide. And the council also wrote a position paper on the topic of housing, which we've included in this presentation. And we believe that a person's home is their sanctuary, where there is control over where and whom one lives, control over the services one receives, and control over the routines of daily life. Next slide, please. So it's a position of the council that best practice in accomplishing integrated housing outcomes for people with IDD, which assures supports necessary for safety and a good life within typical community housing settings and control over what supports are provided and who provides them. And it's also a position that the crisis in housing for people with IDD demands action, and that public housing authorities and private community development entities work together with disability advocates to increase accessible, affordable, and supportive housing. Next slide, please. And finally, it's a position of our council that the creation of affordable housing should not go forward with reliance on models of housing, which by their nature are inconsistent with the rights of people with disabilities and the promise of the Americans with Disabilities Act of 1990, its integration mandate, and the Supreme Court's Olmstead ruling of 1999. So next slide, please. Okay, so there is, in addition to the housing option of group homes, apartments, and regional centers, and host homes that were just discussed, there is what's also called the family caregiver model, also referred to as a personal care alternative. And that's an option to do both under the DD and SLS waivers. The family caregiver model under the DD waiver is the option shown on these slides, and I do apologize for not including the details for the SLS waiver option, but I will address that as well, of course. So there is the option for those parents or caregivers, including myself, who have loved ones living with them and either prefer to maintain having the option to live at home or do not have the choice to make an alternative housing placement within the community outside of their home. So this option is for those individuals. Next slide, please. So a family caregiver is paid in the same fashion as unrelated host home providers, and it is a non-taxable income. And you can choose either the independent contractor or the employee model. And that'll depend on whether you would wish to have employee benefits or perhaps you want to operate more independently. And each model has their advantages dependent on the needs of both the individual being cared for and their caregiver or family member. And daily rates are set by determined SIS levels, and SSI monthly payments are not impacted by these rates. So payments are for room and board, daily support services, transportation, record keeping, expenses documentation, and compensation for the family caregiver is determined by the outcome of a standard assessment called the Support Intensity Scale, the SIS, that's administered through the state. And the result is an SIS score that ranges from 1 to 6 that determines the daily residential rate for the individual. So in addition to the daily residential rates, individuals and services may receive Social Security benefits, which are used in part to make a monthly room and board payment to the host home provider, the family caregiver as well. So your responsibilities would include providing supervision and transportation to medical appointments, community outings, and day programs. You're assisting with hygiene, personal care, medication administration, meal preparation, among other things. Next slide, please. So host homes, PCAs, personal care alternatives, and your own home are referred to as individual residential services and supports, IRSS. And you can choose an approved service agency that has the family caregiver option, employee model, or the independent contractor model. Some, I'm not sure, may offer both. Most will go with one or the other. So a paid family caregiver must be able to meet any requirements of employment that is considered that agency, or as an independent contractor, also specific to the CCB as well. Next slide, please. And the agency you choose to work with as a family caregiver are required to ensure that all services that are based on the individual's needs are delivered as stated in the service plan, that direct support hours are in fact provided, and that there is 24/7 emergency access supports. And there will be home visits from the chosen agency, and that is done just in order to monitor and provide the needed direct services for the individual being cared for. So the daily rates provided for the agency go to the administration, and program fees are based off a percentage of the daily rate, either predetermined or negotiated between the agency and the family caregiver. For the SLS waiver option, which are not on the slides, the funding for this will also be aligned with the SIS level for these services. It does not impact the current funding that'll be made available. A family caregiver cannot, however, be paid to provide services that would fall under behavioral, vision, or dental, medical equipment that might be considered to be specialized. Also under the SLS waiver, there are individual funding limits referred to as SPALs, I hope I said that right, which stand for Service Plan Authorization Limits. And with the SLS waiver, skilled nursing and CNA and home health care services may also be utilized, just not at the same time or to be perceived as being duplicated services that are already being offered under the SLS waiver. And one of the differences between the family caregiver option through the SLS waiver as opposed to the DD waiver is that if it's utilized under the SLS waiver, the 24-hour care is not intended to be provided. Therefore, it would not be the equivalent to the host home model. I would also add there is the ability under some of the waivers, including the SLS waiver, to utilize the consumer-directed attendant support services, otherwise known as CDAS, and which allows for individuals and their families to direct and manage their long-term care services and supports needed to live in their own homes. And one can direct and manage those who provide the homemaker, the personal care, and health maintenance services without having to go through an agency. So one would have more freedom to train and manage and even hire those people to provide those required services. And family members, including spouses and adult children, can be hired as well as family caregivers under the CDAS. Next slide, please. Okay, so in choosing which agency to work through this program, good questions to ask would be, does the agency have any particular requirements in addition to those already outlined by the DDD? Does the agency operate with the employer independent contractor model? Can the agency provide all the hours of direct service needed? What are the administrative and program fees? Is there a way to see the financial breakdown and budget based on the determined SIS level and the service plan? And does the agency provide day program, activity services, respite, or other activities for the individual or the family caregiver? Next slide, please. So you can also find out more information on the Family Caregiver Program and participating agencies from your CCB, Division for Developmental Disabilities, Colorado Cross Disability Coalition, the Parents of Adults with Disabilities in Colorado, Parent to Parent, Disability Law Colorado, or your local and state chapter of the ARC. I'll also add that a good resource would be the Centers for Independent Living. Lots of credit goes to the ARC for having a lot of this information made available online through various resources for parents like myself to search for and learn more on, or to point us in the right direction as to where to turn to next to ask more questions. It is a long process and it can feel stressful and challenging throughout. And agencies and the CCBs need to be ready to offer this option and arm the families with the information needed and guidance in how to get this process started, as well as go over the possible advantages or disadvantages of choosing either the employee or the independent contractor option of this program. Next slide, please. So there are concerns, and it's not just for family caregivers, but everyone as far as housing, and our council in particular has this focus. The major barriers in the community to community living do include long wait lists for underfunded affordable housing programs, Medicaid not allowing funds to go towards rent or other typical housing related costs, being priced out of rental markets across Colorado, crisis level lack of well-trained direct support professionals and other care workers. Next slide, please. There's also difficulty in placing individuals with more significant needs in homes after residential care placement. And transitions for many have been tough and at times practically impossible for others to have the ability or want to take these individuals in. Could also be causing a lot of families to have to turn to that family caregiver option when there's no alternative placement available, or there is the risk of their loved ones having to return back to residential treatment. Next slide, please. And there's concerns for many family caregivers to include caregiver burnout. That's a big one. Lack of community supports and resources. No appropriate alternative placement options. Risk of residential care or treatment facility placement. Least restrictive settings, although always the goal, not always the most suitable, preferable, or safest option at the time for some individuals with IDD. And there's a need for respite, nursing, educational, and day treatment program options. So the Colorado Developmental Disabilities Council will continue to advocate for and support all efforts to provide better housing options for and resources also for those in the disability community, particularly those individuals with intellectual and developmental disabilities. So thank you.
So at this point, we figured before we went on to the other topics that we'd open it up for some questions about rights before we get into the legislation update and resources part of the presentation. I know that there's some questions in the chat that Renee has responded to some of them, I think. Oh, sorry, I didn't start my video back up. So, and I think most of the questions in the chat have really been targeted towards Renee's part. I don't know, Renee, do you want to jump in?
I am starting to answer the questions in the chat. I think, Kristen, you just posted a little bit about what a PCA home is. I wasn't familiar with that. And I was just starting to read that. Would you like to come off mute, or do you feel comfortable coming off mute and talking a little bit about that and sort of what this setting is like? I have never heard of it.
Can you hear me?
Yes, I can.
Okay, thank you. Yeah, so it seems a lot like a group home to me. So my family member is one individual, and then there's two other individuals that live there. It's definitely not at all a family setting, which I've heard from your discussion that PCA is usually talking about a family caregiver setting. So, I mean, they even have rotating staff. So it's definitely not a host home. And they consistently always refer to it as a PCA. And I've just never been able to find a definition for that. They say it's not a group home, but I mean, it seems to meet all the markers of a group home, except for that there's only 3 people, not 4.
Interesting. Yeah. Based on your description, it sounds to me also like a group home, but like you're saying, it has one less person. Maybe I can connect with you offline to get more details about which CCB this is through, or PASA, or things like that. Would that work?
Yeah,
Can
that
we
would be
look
great.
into it together. Okay, that sounds
Thank
great.
you.
Thank you. And I see that Brian raised their hand.
Yeah, I can provide some information on the PCAs if anybody would
great.
like.
Yeah, that would be wonderful.
Yeah, so it's an alternative to group homes in some respects. It's a personalized care alternative. So the staffing, like the way the group home is structured, is person-centered and specific. So, I mean, it could be a variety of settings, have different staffing needs. Some might require 24-hour staffing, some might not. And also there's folks in the community that live independently in apartments. That's considered a PCA setting too, where they'll have supportive staff like on site somewhere, but they don't have staff in the home. That's kind of what a PCA is. So the group home model, like it just has a lot of regulations, and they're pretty limited as to what they can do in some respects. So that's like where the PCA thing is coming from. It's more tailored to the person. So not necessarily, I mean, it could function a lot like a group home, but just not necessarily. Doesn't necessarily have to be congregate living either.
And are those run by PASAs? Is that who's overseeing them?
Yeah.
Okay. Okay. Thank you for that clarification. I learned something too. Thank you.
There you go. Yeah.
This individual one is actually, it's all of the people there are really high needs, just to put that out there.
It looks like Dustin has their hand up.
Yes, thank you very much. So in the conversation up to this point, we had a very clear articulation of rights. Thank you very much, and concerns. The question I would have is, are there any areas where the rights and concerns are in direct contention with each other in a way that would, that we would be surprised by, or that we should really be paying attention to?
This is kind of a matter of opinion, but I think that it's shared by many people that yeah, there's a lot of concerns that we have, that the rights are not being upheld the way that they should be in each of these locations, or each of these settings. To start with the just community apartment type setting, we know that the complaints about discrimination in housing have increased. Whenever there's a shortage of something, then the people who have that have a lot of power. And so anecdotally, what we're seeing when we're talking to people is that they're afraid to make too much noise and fight for their rights, because they know that there's not a lot of other apartments available that they could access, especially if they have accessibility needs. And then with the residential centers and group homes and host homes, all of which we're having shortages of those placements, but also the people who provide care for the people in those placements. And that's making it much harder to ensure that people's rights are being upheld, that they truly are in the least restrictive setting. It is a tough, and we're talking a lot about rights, and I know that the experience that many people are seeing on the ground is that these rights are not coming to fruition or realization. And so the purpose of this presentation is so that people do know, if they don't know what these rights are, know that these rights exist, and then know also people to contact, and what you can do to do some self-advocacy as well around those rights, because right now, with between a housing shortage and a care worker shortage, it's really tough in all of these places. And I don't know if Jennifer or Renee want to add anything else to that. I'm guessing not. Does anyone else have any questions? And there'll be more time for questions at the end.
I do, Kelly. This is Ann Patton. I thought I raised my hand, but I guess I don't see it up there.
Okay, go ahead, Ann.
I just made a comment. I put it in the chat, but another option for families is when the family becomes their own PASA, in order to serve their child that is typically a higher CIS level and unable to find appropriate supports within the typical models in the system. I, for one, run a family PASA for my son, and these are typically PCAs. And so, as I think it was Brian said earlier, yeah, typically people that need a higher level of support, and a number of the folks that I know, their children are older and have moved out, so family caregiver is not an option, but want to live on their own and in a more typical setting than is provided in a stable setting, I will say, more stable than, hoping for the best in a host home, so that's another option too of the family passes. They're becoming more and more utilized, I think.
Thank you.
Especially the ones I've noticed are in the autism community where there's a high level of need for behavioral support and other things that host home models can't really address effectively. So.
Thank you so much, Anne. That's a great comment. I think that'll be helpful for others to be
Hi.
aware.
I just wanted to make a comment to follow up on what Anne was saying, because I also have a high needs adult child who just got out of a ABA center-based behavioral program called Firefly Autism Center. And they did some amazing things with my daughter, but we were just talking about this with a group of parents. You know, when people graduate or they turn 21, your ABA behavioral services drops down to almost nothing. And so you go from this very structured, you know, environment at school, and then all of a sudden, I mean, we're going through this right now. My daughter doesn't really have a place to go during the day and has no behavior support anymore. And it's really, you know, it's really, really difficult. And it seems like, you know, because the day programs don't have to take people who need significant support. And then we also lose the behavioral services at the same time. And so, you know, I've talked to a bunch of other parents. This is a huge, huge problem for people in the autism community or anybody who has a child with significant behavior needs. Is there anybody I could talk to on this call who can help me with this?
I was actually going to say, I stare down that same immediate future. My daughters are a level 6, just became a family caregiver for them. And I'm sorry, I didn't address the PASA agency that you could do. I'm also an independent contractor, and I just started last week for my daughters. But it is a huge crisis, and I share in that. My daughters have severe, significant self-regulated behaviors, and no one will take them. Right now, they're at their ABA therapy, but they're 18, and in a matter of years, that will also be a problem for them as well. So I just wanted to say that there's a lot of us who have that, although it's not a lot of us. I think we're kind of lost in that shuffle. So I just wanted to say I share in that. I'm on the same boat with my twin daughters. They both have those high significant behavioral issues and severe autism. And I know our council is working on various efforts with that. So you could definitely reach out to myself or anybody on the CDDC for that, and we're always talking about it.
Okay, thank you. I would love to talk to someone.
Absolutely.
Okay, sorry, I could not find the screen to unmute. I see that there's a question, and the video box has gone away from me again. I can't see who the question is. Go ahead and ask your question though.
Hello, I had a hand raised. Are you referring to me when you say go ahead?
Yes, yes.
Okay, I just wanted to follow up on to say in response to what Robin just talked about, a way for a group of people in Colorado to try to get this these hours of behavioral support to be increased for people over the age of 21. It's a right under what's called EPSDT. Someone else, that's an early something, whatever. Someone can define it. but that only goes to age 21. Above 21, there are a group of parents on a group called PADCO, Parents of Adults with Disabilities in Colorado. And you can find that reference on slide 35. It has PADCO spelled out on there, and all you have to do is Google it. Or you can just Google PADCO. And if you participate in a group of parents, referred to as PADCO, you can connect with other folks who want to join together and get that increase of behavioral services improved, and the number of hours increased, and the quality of the services dealt with. It's going to take a change in federal Medicaid rules, but it's definitely doable. We just have to get a bunch of people who want to get that over 21 behavioral services current limitation increased. So please respond to that if that's a concern of yours. We can definitely make changes in policy if we have enough people power. Thank you.
Thank you so much. And I think that this is such a great thing about all of us coming together for this presentation. I saw from the attendee list, there's people with all kinds of expertise on this, and being able to come together and share what we're working on and how we're trying to work on these issues, because a lot of these issues are going to take bigger policy changes, unfortunately. But we can make those changes if we work together. So I really appreciate that. I'm going to go ahead and just make sure, I think we'll still have time for more questions at the end, but just go on to the legislative update, make sure that we have enough time to get that and the resources section in, and then we can continue with this discussion because this has been great. Okay, so Jack, you're up.
Great, thanks, Kelly. I will be quick. So my name is Jack Johnson. I work at Disability Law Colorado as our public policy liaison. I do a little bit of work connecting with our federal delegation and our national network to talk about federal legislation, but the majority of my work focuses on work done here at the state level. And I just wanted to provide an update, particularly around the housing work that was done this legislative session. A lot of this is based in community settings, so someone living in a community setting with a disability that still may be impacted by the legislation that was passed. So we can go ahead and move on to the first piece of legislation, which is mediation protections for people on fixed incomes. So for renters on SSI and SSDI, particularly in TANF, there is a new protection in place for individuals who are renting from someone who has 5 or more units. So this is, most individuals are renting from someone who owns 5 or more units, that when the individual is going to be evicted or an eviction proceeding is been started, the first thing that happens is there's a notice of eviction. And then after the statutory period of 10 days after the notice of eviction, the eviction proceeding is actually filed. This new law requires that after a notice of eviction, the renter has the right to mediation, which is paid for by the landlord and the state combined, that hopefully leads to better outcomes, especially for people on fixed incomes who may have certain reasons why those fixed incomes didn't come in on time or had unexpected expenses but will receive back pay. This allows them to have those conversations with that landlord. In addition to that, if the individual is evicted, the current statutory deadline is 10 days between the writ and the execution of that writ. So between an eviction order and when the sheriff will actually show up at a property, this extends that to 30 days for those individuals on this fixed income. Kelly, we can move to the next slide. Thank you. The next piece of legislation that was passed around housing was remote participation for those eviction proceedings. So in a residential eviction, it requires that if a person would like to participate remotely, including the party or any witnesses that the party wants to call, that the court has to allow it. It also helps some fee issues and fee waiver issues, especially for clients who are indigent or who are maybe going back to the last bill on these fixed incomes and who would ask when they're representing themselves to be able to have fee waivers. It makes those fee waivers easier. Kelly, you can go to the next slide. It also prohibits certain kind of redundant fees. So a filing fee on a fee waiver request, which seems a little bit redundant, right? So it prohibits some of these filing fees on certain requests. And then the last thing on the next slide is it requires the courts to comply with federal laws around people with disabilities who are getting accommodations, and also protects individuals who choose to go through this remote eviction process. So for example, if you have technical difficulties or you are disconnected, it protects you from having an automatic judgment entered against you. So this kind of as a whole allows individuals who are going to be evicted the right to go through this in a remote proceeding and the notification that they have that right, which is really important. We can go through the next slide. And I guess this last thing, which is I kind of already encompassed, it includes that when you get a summons for an eviction, that you are notified of that right. So individuals in kind of plain boldface text, and that way individuals who didn't attend this seminar know that they have that right and can exercise that right, which is an important thing for people with disabilities who, for a variety of reasons, have difficulty accessing in-person live court proceedings. We can go ahead to the next bill, which is habitability. So for renters, there are certain guarantees for the way a premises is and whether it's considered habitable. What this bill does is it expands what is considered habitable to include important things like air and water. It also protects damage that may have been done to the property through things like natural disasters, that ensures that if a natural disaster or other damage strikes, that premise can be deemed inhabitable, which allows renters certain legal rights, such as the right to leave and not pay rent and get out of a lease or get reduced rent or things like that. The next slide talks about it requires what's really important is that prior to moving in, there has to be certain certifications and guarantees that it is hygienic and following along that clean air and clean water theme, that the premise is habitable, and provides a duty to the landlord to notify a tenant if there are certain standards that are not met, and that protects tenants from making claims of habitability against the landlord. So if you believe that there is a habitability issue in your place of residence, as a tenant, you have the right to make those claims against the landlord and not fear retaliation. Next slide is a pretty big bill. So this is protections for residential tenants, which expands on some of the rights that Kelly was talking about at the beginning of the presentation, including rights around income checks and credit checks and rental history and things like that. The big changes, I think we can go to the next slide and outline some of the biggest changes, which is that if you are a tenant or a prospective tenant, someone who's looking to move into a location, it prohibits a landlord from asking about your income other than to satisfy the requirement that you make 200% of the total rent cost over the course of a year. So what that means is that in addition to that, it prohibits landlords from asking you to make more than that. So it sets this 200% threshold for the required rental income needs, but doesn't allow the tenant to look at, source of income is already illegal, but type of income, and in addition to that, how much, it caps at how much they are required to look at the prospective tenant's income for that rental application. In addition to that, it also prohibits a landlord from looking at credit history unless there are certain exceptions, including an exception for federal law. And finally, it provides a private right of action for both the state to enforce this. So if there's some kind of violation of this, there can be a complaint to the Attorney General's office, who can investigate and bring in enforcement action. And individuals can also bring their own enforcement action against a landlord who violates this. And the last slide on this bill talks about security deposits, and it ensures that security deposits it allows security deposits to not become a barrier, especially for people on fixed income who, for a variety of reasons, may not be able to pay that large security deposit up front. It allows them to pay with monthly installments over the period of at least half of the term of the lease. Next slide, please. So this is the last one, and this is not for renters. This is for individuals who own the place where they live. So in 2019, there was a tax credit which gave $5,000 to cover the cost of improvements for a qualifying individual. And I added the site for what is a qualifying individual because it's in statute and it's a little complicated. But if it's basically an individual who has a disability, who's looking to make an improvement to their home, can receive this tax credit up to $5,000. This year, the legislature extended that tax credit from which would have ended next year all the way through 2029, and also allows tax credits to span over multiple years. So a project credit in increments. So if you spent $1,000 one year, $2,000 the next year, and $1,000 the following year on a project for an improvement, you could receive that tax credit on a year-by-year basis as you're spending it. The last two things, which are not on slides, which I'll very briefly mention, are a task force which was developed. So this doesn't affect individual rights, but there was a task force that was put into place by the governor and lieutenant governor, which is going to examine some of the high-level housing needs for people with disabilities. The task force is going to produce a report by, I believe it's January of 2025. And so over the next year and a half, what the task force is going to be looking at are some of those rights that Kelly talked about, including things like if an improvement is made, can that improve, does the tenant have to remove that improvement, such as a ramp or a grab bar, and finding ways to make sure that we can make sure that those improvements are left to retain the stock of accessible housing. In addition to that, looking at common spaces and transit-oriented developments. So when we look at, the way cities zone, the way builders build, making sure that, especially in transit-oriented developments, there is a higher percentage of accessible units and units for people on certain types of fixed income, so that they're along the transit corridors of development, which is really important. So that task force is just getting started. I think the official appointments will come in by September. So keep an eye out for that work. And I'm happy to provide the website where you can follow it when they actually get that website up and running. The other thing that the other piece of legislation that I'll just briefly mention was a bill that is going to start the process of examining host home oversight, because there's a lot of variability in what host home oversight looks like, and there's a lot of variability in the quality of host homes. And so I didn't put a slide up because there's no new rights in this legislation, but what it does is it starts the conversation about changing the way host homes do oversight, ensuring that we have a process probably in the next 2 years that allows us to better control the stock of host homes to ensure that as a state, we can weed out some of the bad host homes or the host homes who are not meeting the expectations of the community, and provide more resources to host homes who are performing well, and hopefully increase the stock of high quality host homes. So those are two things on the horizon. And I will just, because I was asked in the chat, briefly talk about Prop 123, which is to say that there's not much to talk about yet. So what the legislature is doing is they've put that Prop 123 money aside. It's primarily focused on local governments. So part of our work at Disability Law Colorado is going to be working with local governments to figure out a way when they tap into that 123 money to allow that money to be used for both affordable and accessible housing. That has just begun. I don't even think local governments can actually apply for the funding yet, but I think the funding pool mechanism is still being set up. In addition to that, that task force that I talked about that's being headed by the lieutenant governor is going to look at ways we can use that 123 money to develop that transit-oriented housing that is affordable and accessible. So 123 is really just getting off the ground in terms of where the money is being used, and we're still trying to figure out ways that we can tap into the money, because there's kind of push and pull between the local governments wanting to retain that money for themselves so that they can apply for those grants and use it on a local scale, and the state who's looking to use it for example, investing in housing on a state level or state-run projects that protect low-income housing and expand low-income housing. So there's not a whole lot of change yet because the state's still trying to figure out the best way to administer those funds. I'm happy to answer other questions now, or if Kelly wants, we can just do it all at the end.
Let's go ahead and save it for the end. Don't think going through the resources is going to take that long. And then we can do more Q&A then. Okay, so let me start my video. Housing resources. So this is by no means a comprehensive list. There's a lot more resources out there, more local resources. We couldn't begin to list them all, or that would have taken 2 hours. A lot of the resources that we mentioned and some we didn't mention are here and present. So make sure that if you guys know resources that have been very helpful, especially for the issues that people are raising, drop them in the chat. Resources for finding housing. This is one where there really is, in almost every locality, there's some agencies that provide housing navigators. I know that their services are not perfect, but they can be helpful. Colorado Housing Connect covers all of Colorado. And then I put some places that are for different localities, but there's also a lot of other different regional housing navigators. United Way of Weld County, Hope Communities in Denver, Partners in Housing in Colorado Springs, Housing Resources of Western Colorado. But there's a lot of different regional housing navigators. Can look them up. You could also call various Colorado Housing Connect could connect you with a lot of those other ones as well. So housing resources for disability discrimination. And let me just note that the all of these resources with their websites are on one of the handouts on the link that Dina provided. That should have also been emailed to you prior to this. Disability discrimination, there's ourselves, Disability Law Colorado. There's also Colorado Cross Disability Coalition, Denver Metro Fair Housing Center, and then other advocacy resources that are not specific to disability discrimination, Colorado Legal Services. the Centers for Independent Living. They don't provide legal services, but they provide a lot of our clients with housing advocacy that can help them to do the applications, to advocate for reasonable accommodations, or for various things that somebody with disabilities might need from a landlord. And Colorado Poverty Law Project, both Colorado Legal Services and Colorado Poverty Law Project help with evictions, which we do not. Disability Law Colorado does not assist with evictions, but both Colorado Legal Services and Colorado Poverty Law Project do. And then Renee, do you want to take this slide?
Sure. Yes. And I think a lot of this has already been covered by both all of you as experts in the audience. And then Jennifer also mentioned the great self-advocacy assistance that the ARC provides. So I want to just highlight that as well for a second time. There's ARC chapters throughout Colorado, and they provide great support for housing and in other areas as well. As far as these other resources, Inclusive Housing Denver is Denver oriented. The Autism Housing Network is a national organization. So that is, national organizations are sometimes more helpful and sometimes less, depending on the context and what you're looking for. And then Mission Supports Program is also local to Colorado. And like Kelly said, I think it is so great that we are all sharing these resources, and I'd love to hear from all of you about more of these, because these were just a starting point for the type of resources we can share.
Okay, so I think we can open it up for more questions now. It looks like Michael has his hand raised.
I do. Thank you, Kelly. So Jack, I wanted to go back a little bit to 1120, the first bill that you'd covered, that among other things, extended the period of eviction to 30 days before the arbitration was over that period. Have there been studies as to whether or not 30 days have been actually sufficient when it comes to getting accessible housing? Because I would imagine that's not always the case by any stretch of the imagination. Are we still going to be pushing for more extensions? Are we in a good place more than I think?
So the 30-day window is kind of reasonable negotiation between what we could get and what we wanted. I think 30 days was important because it's tied to fixed income cycles. Months are tied to fixed income cycles. So it allows, for at the very least, an individual who's on one of those fixed incomes to get another check government assistance that then they can use to afford a first month's payment on a new home. So it doesn't necessarily solve the issue of finding accessible housing because the stock is limited and that's difficult. That it does at least start to address the issue of the fixed income component of not even be able to afford a first month's rent on any type of housing. I think there's more work and conversations right now happening for next year about what does reasonable accommodation look like in the eviction setting, both for stays of eviction proceedings and things like that. But to answer your question, I don't think the 30 days solves everything. I think it was a compromise that at least gets us that income cycle.
Makes sense. Thank you, Jack. Appreciate it.
Okay, so I'm also going to just note there was a couple questions about habitability. One is about a requirement to submit something in writing to the landlord first. I believe that that is correct. However, this is not, we don't we don't work in on the habitability issues. We just noted it as housing legislation that could affect that. There is, excuse me, there is a handout that we provide people on habitability that I will try to find a link to put in the chat. There's another question about habitability and resources for disabled tenants who are dealing with secondhand smoke, both cigarettes and drugs. So this is actually an issue that we have seen a lot. It is a very difficult issue to navigate. Almost anything that deals with the behavior of other tenants and getting a landlord to enforce rules on other tenants is a really tough issue. What I have had people do is ask for reasonable accommodations for increased enforcement. That is usually not super successful, but it can be successful sometimes. And then what's usually more successful is asking as a reasonable accommodation for the landlord to allow that person to move to a different apartment that they know doesn't have those issues. So there's, landlords often know, like, there's a frequent offender of cigarettes, but they can't catch them and they can't do much when they do catch them. And they might know that there's another building that doesn't have that situation. So asking to move to that other building. But it's a tough one. It's really a tough one to try to navigate. And then Jerry, and I'm sorry, Jerry, earlier your name was not popping up on the screen for me, but to encourage all people to apply for housing choice vouchers, formerly Section 8. Yeah, so housing choice vouchers, definitely that helps people to live in community, and they are not perfect, but they do seem to be getting better, both from federal regulations and laws, but also Colorado's been passing these laws saying that they can't apartment owners can't discriminate against people who have housing choice vouchers in renting to them. So yeah, definitely. Okay, so I think that we've addressed the questions in the comments. If we've not done a great job of monitoring that, let me know. But we do have some hands raised. And Jerry.
I just wanted to add on the housing choice voucher issue that for those who aren't familiar with, it used to be called Section 8. And if you're talking about a person with a disability who only receives their Social Security, the SSI, and that's their only income, like $900 a month, and that has to cover, rent and food. The advantage of a housing choice voucher, its new name used to be Section 8, is that only 1/3 of their total income would be the agreed amount for their rent. In other words, if you find a building, and there are building, I think Atlantis in Denver has such a building, and there are lots of others that accept housing choice vouchers. That means that only like $300 a month would be eligible from their $900 to be applied for rent. That's all they'd have to pay for rent. So housing choice vouchers are fantastic. Now they're waitlisted a lot of places, but please, everybody at least apply for a housing choice voucher in your county and in your city. You can apply in both places, and it's a wonderful answer to if you are allocated a housing choice voucher, it can be forever and due to your disability, and it can be just a fantastic help with your reduced rent. Thank you.
Thanks, Jerry. Alyssa, excuse me. Lucinda.
Hi there. I just want to say thank you to the panel for having this Zoom call and webinar, but I did have a question for Jack about the information for the $5,000. I am a homeowner and I care for my 26-year-old child or adult in my home. And does that apply to parents that have children in the home, or is it only if she was to own the home?
I believe it does apply to improvements you make to your home as long as they're a resident at the
Yes.
home. But let me get back to you on that and look at the statute, because it is a little bit weird about who it's applied to and how it's applied for tax bracket reasons. So let me take a look and get back to you.
Okay, I can always leave my info in the chat if you don't have time today, but I appreciate it. Thank you.
And both Jack and I have put our emails in the chat. Somebody asked for that in the chat. And Michael Neal also listed the COVID-19 Eviction Defense Project for eviction protection. Definitely another great resource. And Renee just put her information in the chat as well. Robin.
I noticed that there are several people on the call, including Dustin and myself, who are working with L'Arche Fort Collins, who are trying to build more housing for people with disabilities. We're in the very early stages of this project called Hartsong Hill, but we need to raise some funding to build the homes and to develop the communities. Is there anybody on the call who has connections, who might be able to help us find some funding?
I can offer one suggestion. This is Barb Ziegler. I'm with the Trailhead Project, which is opening in April of 24. We are doing a conference in Colorado Springs in October, specifically to put people like you, Robin, with people who have the money and the expertise and the experience. So take a look at trailheaddevelopers.org. You may have received an email or seen a notice, or you can email me.
Okay.
I'll put my email in the chat too.
Yeah, thanks, Barb. We've talked a couple of times and we did get the email and we're wanting to reach out to you. So I'm glad you spoke up.
Thank you, Robin. And we all know that a major answer to this problem is that we've got to increase the housing stock and the accessible housing stock that's out there. So thank you for that work. And I just want to elevate a question that Veronica asked. I don't know the answer to this question, but maybe somebody in this group does. Can someone speak to the housing areas that will be opening up in the South? I have an individual who is on SLS that wanted me to hear what the state plans to do on helping those who are on SLS and want to live in an apartment such as Tall Tales and the hotel that Wellsprings and the county will be transforming to permanent housing. So if anybody has any information for Veronica, if not, I can try to do some research and we could try to connect offline.
So Kelly, there
sorry.
were a couple of questions up in the very beginning. One of them was around slide 22. If a person has a temporary suspension from housing, where do they go during the suspension so they are not unhoused?
Renee, do you?
I will have to research that to get a definite answer, but I believe that the housing would not qualify as the service. because the whole point is that they aren't supposed to be unhoused. And so I think the temporary suspension was more for services that are being provided. And I think housing would be separate, but I will double check and get back to you on that question. Thank you for that question.
And another one that I saw was, are the CCBs required to do a satisfaction survey every 2 years also? Or is it just the PASAs?
I will also have to confirm that. Everyone is asking very good questions. Thank you. And I believe, Dina, you're going to save the chat so that then I can respond and we can email it out to everyone. Yes. So I will be sure to answer that as well. I believe it is just the PASAs, but I will confirm. Thank you.
Okay, I also want to elevate Zoe Peterson's comment at the end. I've got a tips and tricks sheet I've made for people who are looking to apply for HCV, Housing Choice Vouchers, Section 8. So if anyone would be interested, you're welcome to it. I work at CPWD, a Center for Independent Living in the Boulder area. My email is, and thank you, that's in the chat if anybody wants to access it. Any other questions or comments? We've got a few minutes left. Bob.
Hi, I just wanted to comment on the Autism Housing Network that's been provided as a possible resource for people, and would just suggest that people are careful with that resource. In looking at the options that they're promoting, they all seem to be either congregate or truly segregated in nature. And I think we just need to be careful with those kinds of options. Not to say that I know we are all struggling with looking at a wide variety of options for our sons and daughters at this point for housing because of the crisis we're in. But with that particular resource, be careful with what you're getting into, because at least in analyzing all of the options that they are promoting throughout the United States, I haven't seen an independent style option in any of those examples. So just a word of caution there.
Thank you so much for that, Bob. I appreciate that. Brian.
Hello, lovely souls. Bob, great to see you, hear from you. I also have a bit of experience with the Autism Housing Network, and my experience with them for 7 years, but they didn't always have that name because whatever. And one aspect of them is that they keep meeting the impression that Bob shared, and yet they are creating, and I can't say I've, Bob mentioned he researched the different sites. I can't say I've done that, but I've interfaced with one of the leads, if not the only lead at that network. And sometimes they have a site where people live there, but then they go work somewhere else. And sometimes they have a site where people work there, but they live somewhere else. And to me, that's very interdependent and very community, but it leaves flexibility for options for both independence as well as community interdependence. That's my experience. Thanks for letting me share. And thank you all for hosting and sharing and commenting and questioning and providing some resources today.
Thank you, Brian. Erica.
Hi there. Thanks again for hosting us today. This was really valuable, and it was really nice to see such a great turnout from everyone in the disability community. I work at the Arc of Aurora, and I definitely recognize some names on this call. And I manage our social enterprise called Think Change, and I'm actually working on a project right now that is pretty much a mini documentary storytelling series addressing housing shortages for people with developmental disabilities. So I'm actively working on that, and I'm going to be rolling it out in the fall. So we feel that advocacy is the least intrusive, or education is the least intrusive form of advocacy. So if anyone is interested in hearing about that, I can send, I can put the email newsletter sign up in the chat box, and you can feel free to choose to sign up if you'd like, or I can put my email in here too, and you guys can sign up. But it's just really nice to see that the community is actively addressing this and talking about it, and seeing how we can kind of use our voices to create some change within our community. So thanks again for hosting this. I super appreciate it.
Thank you, Erica. That sounds like an amazing project. I'm very interested to learn more.
Wonderful. Thanks.
Yeah. Jerry.
Yes, I just wanted to talk a minute about a follow-up from the three DD Council, Disability Law, and JFK. Are you guys willing or interested in having a follow-up webinar such as this? And would you send out some kind of survey that asks the question, what would you like to address in a follow-up webinar? So it's not duplicative. So, you know, people can get a recording of this, and I understand everything in the chat will be recorded and distributed also, which is great. But rather than go over some of the same things, I think there's a lot more that we could deal with in a follow-up webinar. There may even be some, we'll call them subject matter experts in the community. And some of those folks could apply to participate in a follow-up webinar, and you three organizations could decide if they were you know, they would be useful. But I hate to see this end with just, you know, just this. I mean, this is great, but this is just the beginning. And items like Proposition 123, which is, you know, is just starting, is going to have all sorts of ramifications, and we'll need to have someone speak to, you know, how to access the money in Prop 123. So that's my suggestion. Thank you.
Thank you, Jerry. And I definitely think I would be interested also on the evaluation. I don't think we specifically ask about a follow-up, but we do ask about people's personal experiences with housing issues, and hope that that could shape future conversations as well. I'll let others speak for their organizations.
We will definitely take your feedback back to our leadership. So thank you for sharing.
Okay, and it looks like we are out of time, which is good because I think I'm turning into a pumpkin. So thank you guys so much. This attendance was great, and everybody's answers and feedback was great. And I really like the interactive dialogues that have been happening in the chat. Appreciate that, and appreciate everyone's attention.
Thanks so much for being here, and we will archive this and send it out as soon as it's posted. I'm not sure that I trust